Hello and welcome once again to another packed episode of Your Family Wealth. I hope you're all keeping safe as lockdown continues to ease and we slowly start to get back to normal life. This is the 5th episode of the show. If you've missed any of the previous episodes, you can catch up on my YouTube channel, Family Wealth TV. Oh, and by the way, the YouTube channel is now called Family Wealth TV, and apart from your Family Wealth show, I'll be uploading shorter videos with news, tools, tips and tricks to help you protect your wealth and pass it on safely to the next generation. As usual, here are the segments for the show.
Coming up, the Family Wealth Quiz. Answer at the end of the show. Topic of the week, case history, guest expert, tip of the week.
So, what do you have to look forward to in today's show? As usual, the Family Wealth Quiz gives you a useful nugget of information. In my topic of the week, I'll talk about trusts. Trusts are an essential part of your wealth protection toolkit, so you need to know how to use them. My case history is another tale of families at war. This time, 2 siblings are battling it out with their brother over their late mother's estate. Many lessons to learn from this case.
If your life policy is written in trust, how much inheritance tax will your estate pay? A. 40%. B. 20%. C. Nil. Be sure to wait till the end of the show for the answer.
Many people have heard of trusts, but assume that they're reserved only for the super rich with very complicated financial affairs, but that's not the case. A trust is a legal relationship that's created when the owner of an asset transfers the asset to someone else for the benefit of another person. There are 3 parties involved when you create a trust. The first party is a settlor. That's the person that owns the assets that will be transferred to the trust. You can have more than one settlor, so a couple can set up a trust together for their children or grandchildren. The second party is the trustee. The assets will be transferred to the trustee so they can manage it for the person or people it will eventually go to. You usually have more than one trustee, and the settlor can also be a trustee. The third party is the beneficiary. As with the other parties, you can have more than one beneficiary. They're the ones that will eventually benefit from the assets in the trust. To set up a trust, a lawyer will prepare the trust deed, also called the settlement deed. A deed means that it has to be signed in the presence of a witness. Once the document has been prepared, the settlor and the trustees will sign the document in front of witnesses. The legal title then has to be transferred to the trustees. Once that is done, the trust is complete. This is an essential part of the process because the trust cannot come into operation without assets. So if the asset going into the trust is a property, the legal title will be transferred to the trustees and their names will be recorded at the land registry. If it's money, it will be put in a bank or invested in the names of the trustees. Although the ownership of the asset is transferred to the trustees, they cannot use the assets for themselves. They are legally obliged to use the assets only for the beneficiaries. The document that sets out the provisions that will apply to that relationship is the trust deed or settlement deed, or it can also be referred to as a declaration of trust. The trust deed contains a lot of information relating to the trust, including who is setting up the trust, that's the settlor, who are the trustees, who are the beneficiaries, the details of the assets going into the trust, the powers of the trustees and the rules they have to abide by, and also when and how the beneficiaries can enjoy the assets. You can also give your trust a name, and most people will do so. So you could call it the Jane Doe Family Trust. It sounds quite grand, but anyone can have one, including you. There are 2 main types of trusts in the UK. With discretionary trusts, you choose your beneficiaries, but the trustees have complete discretion over how much the beneficiaries get and when they get it. This kind of trust gives maximum flexibility so that the trustees can take their decisions based on the circumstances at the point in time when they have to make distributions to the beneficiaries. It's commonly used when setting up trusts for children. The discretionary trust also gives maximum protection of the assets in the trust. That's because the beneficiaries don't have a specific share of the trust assets, they only have a hope of benefiting. For example, if you set up a trust for your daughter who is 42 years old and her children who are 8 and 7, she gets divorced, the trust assets could be protected from the financial consequences of that divorce because she doesn't have an actual share of the trust asset. She only has what the trustees decide to give to her when they decide to give it to her. Most people use this trust as a wait-and-see vehicle because you can't predict what will happen in the future. The trustees can take the appropriate decision at that point in time which best protects the assets. The interest in possession trust is also known as a life interest trust. This is a kind of trust that gives the beneficiaries a right to the income. That means that if any funds in the trust are invested, the beneficiaries chosen by the settlor will get the income from the investment. Here's how it works. So you find that you don't use your holiday home in Cornwall very much anymore, so you decide to give it to your daughter, but you want to use a life interest trust so that your grandchildren can benefit after her. The property is used as a short-let for holiday makers. The rental income belongs to your daughter, but the house is not hers. It remains in the trustees' names to be passed on to your grandchildren in the future. That means that although she gets an income, the capital is protected for your grandchildren. If she gets divorced, the income may become part of a financial settlement, but not the house itself. That will be protected for your grandchildren. The discretionary trust protects both income and capital, whilst the interest in possession trust only protects the capital. All other trusts are a variation on the theme of the discretionary and the interest in possession trust. What type you go for depends on the reason why you're setting up your trust. There are different trusts for different folks. Next time I will look at the reasons why you might need to set up a trust. You'll be surprised, quite surprised at what you'll find out. If you don't want to miss it, you need to subscribe. If you'd like to know more about trust and if it's right for you, please go to my website remiayala.com to get in touch with me. The parties in this case were the children of the late Margaret Wilcox, who died in 2016 at the age of 90. She had 3 children. On one side of this battle was Edward McCarthy, and on the other side were his brother Dennis and sister Leslie. This is another case that has claimed a family relationship and resulted in a great deal of bitterness between Edward and his siblings. Edward claimed that his late mother's home in Wales, which was in her name, had either been held for him under a deed of trust, which she signed in 1998, or that he was entitled to it under her will of October 2014. His sister Leslie was opposed to Edward getting the house. Her case was that the deed was not valid as her mother didn't understand the document or that Edward put her under duress to sign it. Leslie and Dennis also claimed that the October 2014 will was invalid as it was signed by their mother with undue influence by Edward. With 4 wills and a deed of trust involved in this case that included allegations of duress and undue influence, the judge had his work cut out to decide which of these legal documents would prevail. At the heart of the case was their mother's ex-local authority property, which she bought for £16,500, but is currently worth around £160,000. Was the deed of trust giving Edward the property valid? And if it wasn't, then which will was valid? The one of October 2014 giving him the property, or the earlier will of January of the same year giving all 3 children the property? Find out when case history continues. The rest of this week's case history is available in a separate video. The link is at the end of the show.
Is your family being ripped apart by an inheritance dispute? Are you about to squander your inheritance on legal fees? Wait! Why not try mediation instead? It's a great way to resolve inheritance disputes. You get a result that works for you, and you rebuild family relationships. Plus, you save thousands of pounds on legal fees. Best of all, it only takes a day, so you save months and years of litigation. Mediation saves money, saves time, and heals family rifts. No one loses, and everyone's a winner. Go to remyayela.com/inheritance-disputes to get started today. Online mediation is available.
My guest expert today is Sue Day. Sue is a partner in the tax department of leading UK and international tax advisory firm Crowe UK LLP. Welcome, Sue.
Thank you very much, and thank you for inviting me to be on your show.
Well, thank you so much for joining me today. But first of all, I know we're talking about the concept of capital gains tax.
So capital gains tax, or CGT, as we call it, is basically the tax on an increase in an asset. So it doesn't always apply to every asset, but basically it's the difference between what you might sell it for and what you paid for it. So if you're selling a house, for instance, you pay capital gains tax on the difference between what you bought it for and what you sold it for. Capital gains tax doesn't always apply just when you sell something. So it might also apply if you gift something. So if you're gifting something from husband, not husband to wife, but from son to daughter, between siblings or between parents and children.
And what's that new rule that just came into force on the 6th of April 2020?
It's all about changing the date when you report a capital gain and when you pay the tax. So historically, you would put your capital gain on your tax return in the year in which you sold the asset, and then you would pay it on the 31st of January in the year following that tax return. So now the new rules are all centred around having to make a report and make a payment 30 days after the completion of your sale.
And when does the time start running? Is it from the date of completion or from the date of exchange of contracts?
It's from the date of completion. So for in normal circumstances for capital gains tax, the important date is the date of exchange, and that hasn't changed. So the tax point, the date that the disposal took place is actually the date of exchange, but now the reporting date is actually the date of completion, so 30 days after the date of completion. There is one area where people don't need to report, actually, and that's if the date of exchange was before the 5th of April 2020. So if the date of exchange was before then, there's no need to report if you complete afterwards.
And if there's no CGT payable, do you still have to make a report?
No, you don't. So if there's no capital gains tax payable, there's no need to make a report, and there's no need to pay. Well, obviously there's no tax payable. You might still have to put it on a tax return as normal as you would have done, because there might be a different reporting requirement to put it on there, even though it's a loss and there's no tax payable.
What about principal private residence relief? When does it actually apply?
So principal private residence relief applies when you sell your main or only house that you've lived in for or at least some or all of the period. So principal private residence relief, the legislation talks about you having to occupy the property to obtain the relief. Now, if you get the relief, so if you've owned the property and it's your only property and you've lived there the whole time, the gain will be exempt, and therefore there's no need to report the gain or that and there's no tax payable too.
And when does it not apply?
So the rules talk about a house plus half a hectare of land. So if you've got more than half a hectare of land, then part of the gain on that property might not be covered by principal private residence relief because it's outside the permitted area. Now, there are cases where the revenue will look at a garden that's bigger than half a hectare, and look at the size of the house and the way the garden is used, and hopefully they would agree with you that extra land is actually part of your house. But if you're in that situation, you need to think carefully about whether or not your gain is going to be covered by principal private residence relief. So half a hectare is an acre. It's about an acre, and it's important to have a look at what that land looks like. Is it fenced off in a different way? Can it be easily accessed from the house, and those sorts of things? So it's important to take photos actually of where you live, just in case the revenue actually asks you for what it looked like, and you need to produce evidence of the fact that you were using it as part of your garden.
Yes, very complicated, I see.
Everything's on a case-by-case basis. So yes, and you can't just look at the garden and say, if it's more than an acre, this is definitely going to qualify or not. You just have to put your case together and hope you can convince the revenue to agree with you that that's part of your house.
Can you give us an example? I think that will help to drive the point home.
There's an example that I use where there's a small cottage that has about 10 acres of land with it. And when it's sold together, whether that would qualify for principal private residence. The important thing to bear in mind is obviously 10 acres is way in excess of the 1 acre that's allowed, and a cottage is fairly small. So are the 10 acres actually used in enjoyment for that small cottage? And you could still convince the revenue that those 10 acres might be used enjoyment in the full enjoyment of your house, depending on how it's used. Are there horses on it, for instance, that you use? Is it all in one boundary? And it also helps if the house and the land were bought together and the land wasn't bought as something separate. So as we said before, it is all about individual cases. But just because you don't fit within the rules doesn't necessarily mean you won't get the relief.
Is there any general advice you can give to people who are planning to sell their house in the near future?
I think the most important thing with this new reporting requirement is to be prepared. So as the house goes on the market, have a think about whether or not you are going to qualify for principal private residence relief. There may be an example of where you're not in occupation of that property. So for instance, you've gone to live with somebody else, or you've had to go away to work, for instance. So in those circumstances, you need to gather all your evidence. And as you know, when you're moving house, the last thing you do is look for paperwork. You don't want to be looking for paperwork in boxes that you've packed up already. So have a think about it before you move, before you put the house on the market. Gather together all of the information that you have, so that you've got it ready, so that when you come to have to make the report, if you do, you've got everything there ready to make that report. So to report your gain, you have to have a government gateway ID, which you have to apply for. It usually takes about 12 or so days to get that up and running. Once you've got the gateway up and running, you can then actually give somebody else access to it. So if you've got an accountant, or you've got a friend or somebody else who you would like to file it for you, you can actually give them access. But it's important to get that set up way in advance of the 30-day deadline.
Thank you, Sue, for explaining this difficult topic in such a succinct and easily digestible way. It's been really informative. Details for getting in touch with Sue are coming up shortly. Any gift you make during your lifetime other than in a trust is called a potentially exempt transfer. It isn't exempt from inheritance tax when you make the gift, but if you survive 7 years after making the gift, it becomes exempt from inheritance tax. That's why it's called a potentially exempt transfer, because it is potentially exempt when you make the gift. You should make such gifts sooner rather than later, so that you can start the 7-year clock ticking to get the gift exempt from inheritance tax. That's my tip for this week. Make potentially exempt transfers to save inheritance tax.
If your life policy is written in trust, how much inheritance tax will your estate pay? The answer is C, nil. You don't pay any inheritance tax. Some conditions also apply. Visit RemiAyala.com and click Ask Remi if you have any questions about this or anything else featured in the show.
Are you putting off making your will? Not sure where to start? Don't worry, help is at hand. Making a Will by Remi Ayala is a practical book that takes you on a step-by-step journey through the whole process. Learn how to provide for your loved ones and leave them a lasting legacy. Get it now at amazon.co.uk.
That's it for this week. Don't forget to join me next time for another packed episode of Your Family Wealth. I will talk about when you should set up a trust, and my guest will explain how investing ties in with financial advice. Guess what you need to do if you don't want to miss out? Yes, you guessed it right. Subscribe and also click the bell to be notified when the next video is uploaded. And if you've enjoyed the show, then please comment to say so. You can ask questions in the comment section as well. I'd really like you to engage so that I can get some feedback on what you like or what you think I should do differently. Please let me know your thoughts. And if you want a copy of my book, Making a Will, go to my website, remiayala.com. Till next time, stay safe.